Good afternoon from Singapore. My name is Kevin Nash. I'm the Deputy Registrar and Center Director of the Singapore International Arbitration Center. And on behalf of everyone at SIAC, I would like to welcome you to the latest installment in SIAC's series of webinars titled Early Dismissal Procedure under the SIAC Rules, a Guide for Civil Law Practitioners. As many of you would be aware, SIAC introduced the Early Dismissal Procedure in the 6th edition of the rules, the SIAC Rules 2016. This early dismissal procedure is also present in the SIAC investment arbitration rules. SIAC was the first major commercial arbitral institution to introduce this procedure. We have seen now other institutions including it in guidance notes or expressly including these provisions as well. This is somewhat new in the commercial arbitration space, but of course it's well known in common law litigation. We have assembled an all-star cast of speakers from both the civil law and common law tradition who have experience as counsel in litigation, counsel in arbitration, and arbitrators. I will just do brief introductions, but of course I would encourage you all to read their very long and distinguished profiles. Starting with Chan Ho Keng, who's a partner at Wong Partnership LLP in Singapore. We also have Kim Se-yoon, a partner at Kim & Chang in Seoul. We have Eddie Ng, who's the joint managing partner of Tan Ka Kwan Partnership. We have Dong Seok Johan Oh, who's a partner at KL Partners, and Eugene Tay, who's partner and head of international arbitration for Asia at Meyer Brown. The intent with this webinar is to look at this from a civil law perspective, but of course, because we have practitioners based in both Singapore and Korea, there is going to be some comparative analysis as well. To start things out and really to put this into context, I would like to call upon Eddie, who's going to look at common law dispositive motions and a bit of this comparative analysis for the genesis of these provisions in international commercial arbitration. Eddie, I will pass over to you.
Okay, thank you for that, Kevin. I hope I can be clearly heard. Okay, everybody, welcome to the webinar. I actually have a couple of slides, so if I could trouble the person who's actually manipulating the slides to put them on. I've taken this from the Singapore Rules of Court, okay, but these rules are actually very similar in the UK and somewhat similar in Australia. Okay, what we see here are first of all, two rules. Okay, the first rule relating to what we call summary judgment. Okay, that is Order 14, Rule 1, and is used in a situation where a defendant has no defense to a claim. And secondly, we see Order 18, Rule 19, okay, which is really an order for a party to strike out, okay, a claim or a defense when there's no reasonable cause of action. Okay, under this particular rule, you can actually strike it out, you know, if the claim or defense is scandalous, vexatious, frivolous, okay, it is likely to embarrass the fair trial of action, okay, or is otherwise an abuse of process. And one example of abuse of process would be if the matter has already been determined. Again, a plaintiff is seeking a second bite of the cherry. So these are the rules that you see, okay, in the Singapore court rules, okay, that deal in a summary way, okay, with claims or defenses. Now, if we go on to the next slide. Sorry, next slide, please. Yeah, we then see, of course, what it is that Kevin is talking about, which is Rule 29 of the SIAC Rules 2016. Okay, and I think the focus, okay, of this webinar will primarily be on 29.1a, okay, where we're talking about claim or defense that is manifestly without legal merit. That sort of a claim, okay, can be put, okay, before a tribunal for early dismissal. And there are other members on the panel and all that will go into the procedure and exactly how that is done. Okay, this is just to give you something to look at, okay, as I discuss, okay, the court rules as well as the SIAC's rules. Okay, could we go on to the next slide? Now, I put something before you. It might be a matter of debate as to whether the SIAC rules are actually drawn, okay, from this particular rule. This is Rule 41.5 of the ICSID Rules of Procedure, okay, for arbitration proceedings. Okay, in other words, the ICSID rules. And you will see, I think, in the fourth line, okay, but still in the first sentence, you see a very similar language being employed. A claim is manifestly without legal merit, okay? So if we go back to the earlier slide, you see the same language in 29.1a. Okay, like I say, as a matter of history and all, there's a question of whether the SIAC actually drew from 41.5. Maybe Kevin can enlighten us on that. Okay, but certainly because of the similarity in language, you can expect that cases that have gone before the exit, okay, will certainly be of some persuasive authority, okay, in applications before 29.1. Okay. Now, when we come back to the court procedures, okay, the court procedures have been around for a very long time. Okay, and in particular, summary judgment has been around since 1855. Okay, so we've had a very long history, okay, with summary judgment. Now, initially, it was used to facilitate the collection of bills of exchange. Okay, to put it simply, you know, we're talking about checks and all that, and checks have been dishonored. It was a very quick way to get judgment based on a dishonored check. And that's really how it started with. Okay, and you can see the utility in this type of procedure for that sort of an action. Okay, really the purpose here is to save time and cost, okay, for the plaintiff to be able to get to its relief quickly, and also not for the court's time to be wasted, okay, in something that doesn't need to be heard in a trial or an evidentiary hearing. Okay, since 1855, okay, summary judgment has been broadened such that it now includes claims in libel and slander. Okay, these are claims in defamation. Previously, they were not allowed because, you know, in these claims, you actually had a right to a jury trial. Okay, that's no longer the case, okay, for a number of jurisdictions. They have been expanded to include admiralty actions, whether it's an in rem action or in personam action. They've been included to they've been expanded to include claims for specific performance, where you're asking for a contract to be performed specifically. Claims for declarations, okay, where you want the court to declare that one party is in breach, or you want the court to declare that a certain contract has got a certain, you know, interpretive effect, okay, and even in claims for an injunction, okay. In other words, if you're seeking to prevent a party from doing something, it can be the subject of the summary judgment procedure. So clearly, the courts and users of the courts have seen great utility in using, okay, summary judgment, okay, and it has been in our court rules since 1855. Now, proceedings of similar nature, okay, made an appearance, and we saw this earlier in 41.5 and the exit rules in 2006. Okay, so this is actually quite a number of years down the line. Okay, before this type of summary procedure was introduced in the exit rules. Okay, and some 10 years later, SIAC then included it in the 6th edition of the rules. Okay, and that's 2016. However, there are very important differences between the court and arbitration procedures. Although it can be said that they all share the same rationale. In other words, if there's really no reason for trial, okay, let's not waste time and cost fighting it out in an evidentiary hearing. Now, differences are really these. If you're talking about summary judgment, okay, the summary judgment procedure affirms the plaintiff's claim. It ultimately results in judgment where there's no triable issue. Now, early dismissal, okay, does not just cover, okay, a claimant's claim. It also covers the possibility of dismissing, it not just covers, okay, the possibility of disaffirming a respondent's defense. To say, well, respondent, you really have no defense. But it also includes the possibility of showing that the claimant's claim is without legal merit and therefore should not continue. So in that sense, the scope of early dismissal is actually broader, okay, than that of summary judgment. But notice the language, okay, of 29.1a. Okay, what falls to be determined are issues, okay, legal issues, issues for which, you know, one party can clearly show are without legal merit. Okay, it doesn't appear, at least based on the wording itself, that a tribunal is empowered to consider factual issues. And because of that, although the scope of 29.1a, okay, is broader, okay, because you can dismiss either a claim or a defense, okay, the inquiry itself is in fact more limited because we're talking about an investigation into pure legal issues without considering the facts. Okay, now it doesn't mean that in summary judgment in court, okay, you have a full investigation of the facts. Okay, that quite defeat the purpose of that sort of a procedure. But you know, there'll be times where you can clearly see that an assertion being made by a defendant is contrived, and those can be rejected out of hand and will not deter a judgment from being given. So if a defendant was to take inconsistent changes in position, inconsistent positions, okay, that will clearly be something that can be raised to the court, okay, to show that there is really no basis, okay, for parties to go to a trial, okay. this type of investigations, I said, do not fall explicitly under 29.1a. And because of that, it cannot be said that Rule 29 is really arbitration's mirror of the summary judgment procedure. Yeah. In fact, if you take a look at it, okay, Rule 29 is a closer, okay, approximation of striking out. Okay, and maybe we can go back to that slide. Okay. Okay, that's right. Okay, this particular slide is a closer approximation of Order 18, Rule 19, 1A. Okay, when the court may strike out a claim or defense, if the claim or defense discloses no reasonable cause of action or defense. Yeah. And in terms of striking out, okay, it's really a procedure to remove claims or defenses which are legally unsustainable. Okay, it is not at all a factual inquiry. In fact, if you were to apply for striking out under Order 18, Rule 19, 1A, okay, you're not allowed to file affidavits. Okay, so the court doesn't consider the affidavit. The court simply considers, okay, whether this defense is something, okay, that is valid at law, okay, or this claim is something which is legally sustainable at law. Okay, and I give you some examples from the common law. So if you were to run a defense of contributory negligence to a claim in fraud, okay, the common law has established that this type of a defense is actually impermissible. Okay, and as a result of which, okay, that could lead to the early dismissal of that defense. Yeah, if you use the Rule 29 procedure. Okay, or it could be, for example, a claim in misrepresentation. We can demonstrate that the claim in, the misrepresentation is one that no reasonable person could have believed in. Okay, and as a result of which, the claim in misrepresentation is clearly unsustainable. Or it could be a very simple time bar defense. Okay, where the claim is being commenced after 6 years, and therefore there's no longer a right to bring an action. Yeah. Now, coming back to summary judgment, okay, in summary judgment itself, okay, you don't necessarily have to just determine whether a claim is right or not. You could also, under a separate rule that I've not put into the slide, okay, put before the court a question for the court's determination. It needs to be a question of law or the construction of a document. Now, this has to be an issue that's very important, okay, in terms of the claim itself, or in terms of the defense that's being run by the defendant. It may not ultimately be the entire issue in the claim or the entire issue in the defense, but it has to be something that has got significant impact on a claim or a defense. And if you can show that it has the impact, then well ahead of the trial, okay, you can actually ask the court to take a look at this particular issue and come, okay, to an opinion on it. So actually this particular procedure is now commonly used in defamation actions, okay, where parties will then ask the court to determine what is the meaning, okay, of this particular defamatory statement, yeah? And that meaning will then determine, of course, whether certain defenses are valid or not, okay? Okay, I think my time is going to be running short. Okay, under summary judgment, okay, the court has got very limited discretion to give leave to defend when there's some other reason for trial. Okay, this is known as the exception in Miles and Bull. Okay, Miles and Bull being an old English case in which the court actually exercised the discretion. Okay, and it is really being used in very limited circumstances where the court cannot see the defense for the time being, but nonetheless is sympathetic to the defendant and feels that if given an opportunity, okay, through discovery, okay, which is disclosure, through interrogatories, okay, the defendant might be able to establish a defense. Okay, so I'm not sure whether something similar, okay, is present in the SIAC rules. I think Eugene might be able to enlighten us on that. Okay, so that's what it is I have. Okay, hopefully what it is I've said is clear. Okay, and of course, you know, later on when everybody else has finished their presentations, I would welcome questions, okay, on this. Thank you.
Eddie, thank you for that. That was excellent. I have some preliminary observations just from the institutional side. In terms of the influence from ICSID, and as you mentioned, Eugene will be touching on this, what we always say is that it is influence. One thing, rather than, I suppose, just taking a provision and applying it, we had to give some thoughtful consideration. We looked at the ICSID jurisprudence, the choice to have early dismissal of both a claim and a defense, to not make it time bound, and then actually expressly to have something manifestly outside the jurisdiction of the tribunal, which is found from ICSID jurisprudence. If I could just put one question to you, because of course you're active at all levels of the Singapore courts, Singapore International Commercial Court, arbitration. You pointed out the important differences between these common law dispositive motions and Rule 29. From a tactical standpoint, given these differences, when you would wield one of these provisions, does that change? And to say in arbitration, do you have to think about potential enforcement?
Well, the difference will really be because under the Singapore court rules, there's now a time limit, okay, for you to be able to commence an application for summary judgment. Okay, one tactical reason to use summary judgment, even if you don't think that you can actually get summary judgment, is basically you want to suss out, okay, what the defendant has to say. Okay, so you want to put your case out there very early on because you know that they're unprepared and all that. You wanted to take a position on affidavit as to what, you know, their defense actually is. Okay, and if it later turns out that you try and run a different story, you can then point out the differences, okay, later in the hearing itself. Okay, so that's a tactical use of summary judgment. The threshold, okay, for striking out is actually far higher, okay, than that of summary judgment. And that's because you have to demonstrate, okay, there's really, okay, something which is legally unsustainable. And the point at which case law is developed to has made it actually quite a high threshold to cross. Yeah. Okay, so you could show that a defendant is, you know, running a contrived defense and still get summary judgment, but to be able to strike it out, okay, is a bit of a tall order. Okay, so because of that, and because, okay, at least under Order 18 Rule 19(1)(a), it really concerns, okay, only legal issues. There isn't that tactical aspect, okay, to starting a striking out application, because you're only talking about the law here, okay, and you could take a position on the law on day 1 and take a slightly different position on day 15. Okay, so there isn't really the tactical aspect, and it's very, very hard, okay, to cross a threshold, okay, and of course nobody wants to throw money away, okay, pursuing something that ultimately is not going to be effective. Yeah.
Yeah. Okay.
Okay.
Thank you. So we've set out the common law position, the background and the inspiration for the SIAC rules on early dismissal, but of course what we're focusing on here in this webinar is looking at the possibility of summary procedure early dismissal in civil law countries. As an observer, when I look at things with you, and there really is international arbitration practice, and you certainly exemplify that. There's not this same strong common law and civil law divide. And I think if you look at some of the use of Rule 41.5 of ICSID and what we're also seeing in our cases, I think that you're seeing that, is that civil law practitioners are able to use these provisions. I'm wondering, and if you could give us a background on what the position is in Korea and in Korean courts.
Yeah, good afternoon, everyone. Thank you for attending this webinar, and I have the difficult job of having to explain like the position of civil law jurisdictions, which may differ. So I'll have a very brief explanation of civil law jurisdictions position in general, then I'll delve into the Korean court's position and Korean law. Generally, civil law jurisdictions do not have the dispositive motions that are called summary judgments and motion to dismiss based on whether you are from the defendant side or the claimant side. But the parties can achieve the same result if they agree that they'll stipulate on the facts and they'll just ask for the court's decision on legal issues that may achieve something similar to a summary judgment. But still, because they do not have dispositive motions as per common law, they cannot force the court to do it the way they want, as in a summary judgment. However, most civil law jurisdictions have something called interim judgments or in-between judgments or judgments during the proceeding of a court proceeding. So it is one sort of earlier dispositive motions methods, and it does get rid of some of the issues if the court decides to use that. So these are the judgments used in the middle of the litigation proceedings to dispose of a certain issue, such as jurisdiction or merits of certain claims. Each jurisdiction differs in the scope and effect of such interim or in-between judgments. Some allow them on jurisdiction only, the others allow them on merits as well, the others allow them on liability and quantum. So when it comes to liability versus quantum, they allow them on liability. Some allow separate appeal for these judgments. Some do not allow any separate appeal for these judgments. So they all differ. In Korea, I would say the correct translation of such judgment would be in-between judgment rather than interim judgments, because it's something that you get before the final judgment and after the start of the proceedings. But I just call it interim judgment anyway, because people will think in-between judgment is a very strange term. According to Article 201 of the Civil Procedure Act of Korea, the court can render such interim judgments in 3 cases. The first, when it is necessary to dispose of a separate and independent claim or defense. This sounds a little close to the Rule 29.1 of the SIAC rules. But the interesting thing is this is only allowed when the court is going to deny such a claim or defense. The reason is the court wants to decide and deny that and then move on with the rest of the litigation. So if the court is not going to deny it and it becomes something that is going to end the case, the court will have to do it in a final judgment. They cannot do it in an interim judgment. Now, second case is where it is necessary to deal with a disputed matter or disputed issue in the middle of the proceedings. The traditional example would be the jurisdictional defense or whether a lawsuit has been properly withdrawn. If if the court finds that there is jurisdiction of the court, then it will move on with the final judgment. Also, if there was a withdrawal of the lawsuit, but the defendant decides to object to that withdrawal, if the court decides the case has not been withdrawn, then the court will move on with the case. In both cases as well, as with the first prong, if the court decides that there's no jurisdiction, if the court decides that the lawsuit has been properly withdrawn, then the court will end the case there with the final judgment. So the interim judgment does not kick in. The third will be where there's a dispute between liability and for both liability and quantum. Then theoretically, the Korean court can decide on the liability first. So when you think about the jurisdiction and liability issues, this looks more like the bifurcation that we see in international arbitrations. So the Korean court can do that. That said, even in those cases above, although the court can do it, the court seldom or rarely ever does it. And it is because of several reasons, one of which is the interim judgment is not subject to separate appeal. So you have to, as I explained, the interim judgments are for the purpose of keeping the lawsuit going to the final stage. So once the final judgment is entered into, then you can appeal on the whole judgment. So if you cannot appeal in the middle and have to wait for the final judgment, and once it goes on to the appellate court decides the case de novo. So they will look at everything again, and they will not be bound by any interim judgments of the lower court. So there is actually little merit or little upside in the court doing an interim judgment in the middle of the case. So you wait all the way to the end of the proceeding to get a final judgment. And that is why, although if you see the provisions themselves, they look much similar to what you can get under 29.1 in the SIAC rules, and they even look similar in some instances to summary judgments or other dispositive motions, you do not actually see a case which is dealt that way. Then let's think about a situation where you have a jurisdictional defense based on an arbitration agreement. You don't want to definitely go into the details of all of the merits of the case before you get the case kicked out of the court based on an arbitration agreement. So what do you do if the court is not going to decide on jurisdiction first? What I did and succeeded in, and I think at least for arbitration agreements, the Korean court tends to help the parties do that, is to actually ask the court to review the jurisdictional defense only and then close the proceedings. Go deliberate. If they think that the court has jurisdiction, court does not have jurisdiction because the arbitration clause is valid, then they can render a final judgment. dismissing the case for lack of jurisdiction. If they deliberated and found that actually the court has jurisdiction because there's some invalidity issue with the arbitration agreement, they can reopen the case and go until the end of the proceeding and decide with the decision that the court has jurisdiction. If the court runs it that way, at least they will, in the middle, without actually committing themselves into an interim judgment, they will be able to at least indicate to the parties that this is what we think. And if the parties do not agree with the indication, they can provide further evidence down the road before the final judgment about the jurisdictional issue and still fight about the merits as well to get the final judgment. So that will be the tips for Korean players if they want to fight about jurisdiction, which is a simple thing as the existence of arbitration. For other jurisdictional arguments, it's very difficult to do that because often jurisdictional arguments are very closely tied with the arguments on facts that are related to the actual merits of the case. So in short, while we do have early disposition tools in civil litigations, they are seldom, if ever, used. And I understand that in other jurisdictions as well, civil law jurisdictions, they do not use this very often. But if you actually look into the details, if they can be utilized and used, they will sometimes be wider in scope than the ED proceedings you have in the SIAC rules. That will be it for me. Thank you.
I have a couple questions that immediately occur, and we'll be talking about the manifest standard throughout this webinar. Have the Korean courts articulated a standard for these interim judgments, these in-between judgments, and how would that compare to the unruly horse of the manifest standard?
Yeah, actually, there is no language in the Korean Civil Procedure Act about the threshold that the court is supposed to apply. So, and coupled with that, as I explained, these interim judgments are actually used to kick out these arguments or issues so that the court can move on with the case. Instead of kicking out the whole thing and dismissing the whole lawsuit, the Korean court is not bound by any particular standard. They just need to apply what standard that they apply to any of the issues that they do. No manifest requirement.
And have you noticed with your clients, and of course you have clients from both common law jurisdictions and civil law jurisdictions, when the tactical planning raises perhaps the specter of early dismissal, do you see a difference in comfort, or do you find that users from both civil law jurisdictions and common law jurisdictions are at least open to consideration of this possibility?
Well, at least from my experience, my civil law background clients do not think about this very often. Yeah. And I think for lack of experience, maybe and lack of the culture of putting this forward, we also do not that often recommend this. So I'll be, as a practitioner myself, I'll be interested in getting to know what would be tactics or the tips that I should take away from this seminar.
Yeah, we noticed something very, very similar in our SIAC cases. Is that really it took a while for users to get comfortable with these provisions, and what we first started seeing is parties raising the specter of the provisions. So maybe not necessarily invoking it, but you might have a respondent that says, "Well, we intend to apply for an early dismissal of the claimant's claims." And I think that now that you look in the last couple of years, the amount of usage has really increased. So it does take time, I think, for users to get comfortable with these provisions, especially because it was so new in international commercial arbitration. So thank you very much for that view from Korea and civil law jurisdictions.
Thank you.
We will next proceed to Ha Keng. Ha Keng is, of course, very active in SIAC arbitrations as an arbitrator, as counsel, and particularly with parties from civil law jurisdictions. Ha Keng, we have asked you to outline the provisions of the SIAC rules, and this is really the heart of the discussion. So I'd welcome all the other panelists, of course, to provide their contributions. Ha Keng, if I could pass it to you, please.
Thank you. I have some slides. Could I trouble the SIAC put it up? Thanks. Next page, please. 안녕하세요. I'm trying to deliver this webinar in Korean. No, I'm just joking. Let me go straight to the rules. Next slide. Next slide. I think Eddie had shown you the rule earlier. If I may just read it so that you get a better sense of it. So it's very clear. SIAC spent our effort drafting the rules because they make it simple and clear. And it's the message is very clear that you can apply, a party may apply to tribunal for early dismissal of claim or defense on the basis that the claim or defense is manifestly without legal merit. And this one is a legal issue. And under B is where the claim or defense is manifestly outside the jurisdiction of the tribunal. Next slide. Who can apply? Clear. Both parties, claimants and respondents. What is liable to be dismissed? Claims and defenses. When can you apply? The rule is also clear that you can apply any time after the tribunal has been constituted. There's no specific time limit. There are for summary judgment, as Eddie has mentioned. In exit rule, there's also a time limit. I think it's 30 days from the tribunal's constitution. But I would say that because the Rule 29 refers to early dismissal, obviously the later you apply, the less likely a tribunal will agree to hear the application. I remember that the draft of the rule had some deadline, but this was taken out. So let's go into next issue is what are the grounds? The speakers before me have mentioned the focus is on the word manifestly. And I think Korean, it means myongbegan. If I'm wrong, please correct me. And there's some jurisprudence, as Eddie has mentioned, in the exit rules. So perhaps we can take a look at that later on. Next slide. How is Rule 29 intended to operate? You have to consider Rule 29 in the context of the general SIAC 2016 rules, because there are broad range of procedure powers that are granted to tribunal, including one of what's Rule 22, which I could talk about later. But Rule 29 is very specific. It is only to operate where there is no substantive factual dispute. So the facts will not be the issue. What is the issue is the law. Is there or is there not a basis to make the claim or the defense? Eddie has mentioned something like about contrary negligence in the fraud case. So if the law is clear that you can't cite certain defenses, these are the cases where tribunal can be invited to strike it out. And it is not intended to operate with detailed evidential inquiry in a hearing, especially for the limb A. B maybe, but A is meant to be just on, focuses on the law. Next slide. As we have heard from the previous speakers, the word manifestly is not defined in the SIAC rules. So there's one query. First, is it the same test as the prima facie test in Rule 28.1? If you look at the SIAC Rule 28.1, if before the tribunal has been constituted, a party objects to the existence of the arbitration agreement or to SIAC administering the case, the registrar may refer this issue to the court to decide whether or not on a prima facie basis the arbitration should proceed. So this is one hurdle that someone can make the claimant cross. And prima facie, I understand it means igyong, you know, and I'm trying to be Korean. What we can do is we get guidance on the word to understand the word manifestly from summary judgment or striking out, as Eddie has mentioned. And also, I think Eugene will talk about it more under summary disposal under the exit Rule 41.5. But just to give a very brief preview of this, well, it means what it says. Manifest means it's very clear, easily understood, recognized by the mind. It should be fast and quick to explain to the tribunal and obvious on its face. I think what the tribunal will be asking itself is this: do I have all the materials before me to make a decision on the question, or do I have to wait for witness statements or lots of other material? If I can decide it today, then this is a case that's suitable for summary determination, and it's manifestly clear that I can strike it out. Next slide. Next slide. Yeah. Next slide, please. Next, yes. I'll give you just some examples of what kind of cases that might be suitable. Eddie has mentioned the limitation period expiry as one of those cases where it's very much a legal issue. And if there's issues of res judicata or previous awards, this could be something that it's on its face, you can argue. One possible area is that doesn't look like law is admissions. If the defendant files a bare defense, just denying the claim, but you can actually have evidence of previous admissions, I would suggest that this is something you can say that it amounts to admission at law, that you can get the defense struck out and try to get an award. That's just my suggestion. Because in the rules of court, we have this other procedure called judgment by admission. And it's also a summary procedure where you can apply. And I would say that it will be quite similar. Next slide. I'll go on to just, Eddie had shown the rule, the entire rule, but I'll go on to just briefly explain the process. So Rule 29 says that when you apply for summary dismissal, you have to state the facts and legal basis supporting the application. Once the tribunal receives the application, they have a discretion. So you have to cross the first hurdle. You have to convince the tribunal to allow the application to proceed. And if they decide to do so, the tribunal must give the parties the opportunity to be heard before making a decision. And I would suggest that because you have to convince the tribunal to accept the application, when you apply, you should also explain why it is suitable for summary determination. Then there's then the issue whether or not the respondent should be allowed to say why it is not suitable before the tribunal decides. So it will depend on tribunal whether or not they want to give the respondent a chance to, before they exercise the discretion, or they can go straight into the hearing itself. So I would suggest that a more careful tribunal would allow the respondent to make a very quick response whether it's suitable or not. And that will help them decide, rather than they just hearing one side of the coin. And Rule 29.4 also makes clear that a tribunal has the option to either make an award or an order, and reasons can be in summary form. You have to deliver within 60 days of filing, unless Kevin thinks that there's some exceptional circumstances like COVID or the World Cup. I mean, I don't know. So I will ask him to explain to us some of this. So at this juncture, I would like to, because I'm the in-between speaker, I would like to just hear from my fellow panelists how they would exercise discretion. What do you think is the extent of the opportunity to be heard? And for Johan, I would like him to perhaps discuss whether it should be a form of order or award and when it should be. And maybe Kevin can also just explain what would be considered exceptional circumstances. So could I get assistance from my panelists, whether they want to chime in, please? Or I arrow?
Well, I can start with some reflections, and in particular, of course, you would remember that previous public draft with your eye for detail, but that was an important choice, and that's part of the 30 days from the constitution of the tribunal, similar to ICSID. And there's obviously there's a connection and a relationship with the two-stage test and the 30 days, and to a certain degree, the nomenclature of early dismissal, because it doesn't necessarily have to be early. What I was particularly interested about, and what I think is a very good ground for discussion, is your comparison of the prima facie standard versus the manifest standard. But we can also take that to one greater degree of analysis. With this two-stage test, what is the standard for allowing an application to proceed? We know what the standard for the grant is. It's the manifest standard, and you have pointed out some of the ICSID jurisprudence, say Transglobal Petroleum, but what is the standard for allowing it to proceed? I also thought it was important, and we certainly see as a matter of SIAC practice, the potential dangers of a bare defense. Could there be an application for early dismissal if a respondent just issues a very bare defense to a notice? We've also wondered, and we've looked at, is this perhaps going to discourage unmeritorious claims. In terms of the exceptional circumstances, if you canvass when there can be an extension for this 60-day period, if you canvass all of the institutional rules, there are very few that actually will define the circumstances that would be exceptional. This has been our similar experience in our participation in Working Group 2 on fast-track procedures under the UNCITRAL rules. Effectively, what you want to do, and what we control to a certain degree because we review awards on early dismissal, is that you want it to truly be exceptional. You don't want to be granting these as a matter of course. And with that quick institutional view, I certainly pass it to the panelists because there are a lot of items to discuss here.
Kevin, this is my... Sorry, go ahead, Steve. Go ahead.
Thank you. I have some questions regarding the standard of, without needing any detailed evidentiary inquiry. So if a party brings this application and the other party says that it can only be decided after reviewing the facts of the case based on the evidence to be provided, will that stop the tribunal from looking at this any further and dismiss the application, or will that not affect the tribunal? The tribunal will only need to decide based on what is before the tribunal as of that date.
Yeah. Okay, speaking for myself, of course the respondent is going to say it's not suitable. I mean, that's expected. The tribunal really has to see what is the focus of the application. If it is just based on legal basis, then there's no need to look at factual evidence. If it's a jurisdictional issue that may affect the factual evidence, the tribunal should ask the question, what else do I need to make the decision? If I can decide today, then there's no need to take this next step. And I think Eddie mentioned earlier in our discussion about some respondents may want to build up a defense only through this document production or cross-examination or interrogatories, and these are certainly things that perhaps the respondent can cite, and the tribunal will decide whether or not it's relevant in that case. I had when Kevin spoke about the prima facie test and the manifest test, I think it's quite different because for the prima facie case, all the court has is the notice of arbitration and the response, and they make a decision based on that. I suspect for the summary dismissal is where all the memorials have gone in, or at least the defense proper, and you really have to articulate your defense in full at that stage. So it won't be just a quick look. And I think for Order 14, as Eddie can explain, the word prima facie also appears and as a part of the test, and perhaps Eddie can respond to some of the points.
Yeah. Well, under Order 14 or the summary judgment procedure, okay, there isn't a separate stage for the court to consider whether we want to allow the summary judgment application to proceed. So if you do file it, okay, it will mean that a defendant needs to file a response, okay, through an affidavit, and then you have an opportunity to file a reply, and the matter will then go for hearing, okay, before, commonly is before an assistant registrar, okay, at first instance. But at the hearing itself, okay, the court will then consider, before even thinking about whether it wants to give summary judgment to a plaintiff, about whether there is even a prima facie case, okay, that the plaintiff has made up. Okay, this is what Hawking is referring to. So if you don't even have a prima facie case, and there are all kinds of questions, okay, about your claim, okay, then this is clearly not an appropriate claim, okay, for the court to then consider, okay, entering judgment against the defendant on. Okay, in other words, your own house is not in order. Okay, it's not a situation where the court will then allow you, okay, to go ahead and attack, okay, somebody else. Okay, I just wanted also to weigh in on something that Kevin had asked about under what circumstances would this discretion be exercised. Okay, I can think of a number of scenarios, but one scenario which fairly commonly appears not under summary judgment, nor under striking out, but under another procedure, a procedure for preliminary determination. The court will always consider ultimately, okay, if I allow you to put this question for the court to consider, okay, for the court to then opine on, okay, is it going to lead to any saving of time and cost? Okay, so that is a key consideration. And I can see how that sort of analysis might play out in early dismissal, where either a claimant or a respondent, okay, has got multiple claims or multiple defenses, and knocking out one will not prevent the evidential hearing and will not prevent the same evidential ground from being traversed, okay, by the parties when they come up for the evidential hearing. So in that situation, okay, I could see that a tribunal might then think, well, is there really a point? Do you really save time and cost by hearing this application to knock out one amongst many claims or one amongst many defenses? Okay, so that's my 2 cents worth to Kevin's question.
Does Johan want to speak about the difference between the order and award and when it's appropriate?
Actually, due to the time limit, I don't think I handled that issue in my presentation.
So, okay, so perhaps I'll just suggest that if you are going to dismiss an application, the order might be the easiest way to do so. But if you are going to allow a dismissal of a defense and to grant an award would be the appropriate way of doing it. And because award is enforceable in the new convention countries. And I suppose, Kevin, the award will be subject to scrutiny by the SIAC, correct?
Yeah, exactly right. And that's where the 60-day limit and whether or not this needs to be extended. You also have to build in the time for SIAC scrutiny.
Right. Okay, so I try to finish my presentation pali. Next slide, please. I think this is mentioned by my previous speakers. Exit started the procedure in 2006. SIAC introduced Rule 29 in 2016. I wouldn't use the word influence. I'll use the word inspiration. Perhaps it was inspired by exit rules. And after SIAC introduced, other arbitral institutions have also introduced express provisions in their rules. The SEC in January 2017. There are yet other institutions that did not want to introduce express rules in the new version of their rules. But what they try to do is to rely on the broad discretionary powers of the tribunals as the means to adopt summary disposal under general case management powers. And next slide, please. So the ICC is one of them. And what they did was the 1st of January 2019, they introduced the practice note, which I think is inspired by SIAC because they use very similar words. And they say that you can determine manifestly unmeritorious claims or defenses under Article 22, which is a very catch-all provision that relates to general case management powers to conduct the arbitration in an expeditious and cost-effective manner. Next slide. And it's quite similar about the how prompt should be applied, and that they give the tribunal the full discretion. Next slide. And the tribunal will consult parties on the procedure to be adopted, and they say there shouldn't be presentation of evidence. That should be exceptional, and there's no deadline for the award, but as promptly as possible. That's under ICC. But as I say, it's quite similar to Rule 29. Next slide. One of the issues that's been critiqued was that you introduced this Rule 29. Now a party objecting to jurisdiction has 3 bites of the kimbap. They can complain under Rule 28(1). They always could file a jurisdiction objection under 28, and that's 14 days from the defense or from the issue arising. And this could be decided either as a preliminary issue or together with the merits. And now they have this new objection under Rule 29. So in effect, it's 3 bites of the cherry. Next slide. Someone else will touch on this later, but there are concerns, as Sayun has mentioned, that someone with a civil law background may think that you might have problems enforcing it in a court that do not have the equivalent of the summary court procedure. The judges might be more sympathetic. I would suggest that if that's the agreed procedure, the court should recognize that parties are free to adopt these expeditious and cost-effective ways to conduct the arbitration. And here is where SIAC approach of having the express rule would be more effective rather than to have it in a practice note that is not, because when parties contract, they do not look at practice notes. They might look at the rules, but they don't look at everything. And they're deemed to agree to that. I think next slide. Kamsahamnida. So I will leave more time for my fellow speakers. Thank you.
Thanks, Hawkeng. A lot of these issues, of course, are going to be touched on by the rest of our speakers, and we'll see if we can circle back on a few. Johan, as Hawkeng intimated, we were hoping that you could provide us some practical experience with early dismissal, how this might interact with dispute boards. Of course, you represent some large construction interests. Certainly SIAC's experience has been having big project disputes with Korean parties. So we'd be very interested to hear from you.
So thank you, Kevin. So I'm going to talk about the more practical and more specific issue. So as my practice is focused on arbitration of construction and infrastructure dispute, and I understand many of you are Korean parties from construction and infrastructure industry. So it seems to me that it would be useful to use the time allocated to think through some practical consideration in the use of early dismissal procedure in the context of construction arbitration, and in particular, how this procedure interacts with dispute board or DB proceedings. Rather than speak in the abstract, let me provide a brief hypothetical based on my experience. This situation would perhaps be all too familiar for many of you. So there is a piece contractor who has some claims for additional work against the owner. These claims fall outside the contractual regime for variations. The parties continue negotiating over them for a while, and as the project comes to an end, the contractor realizes many of his claims were raised way back during the project and concerned work that was completed much before. These claims are now at risk of getting time barred. The contract has a multi-tier dispute resolution clause that prescribes certain DB procedure followed by arbitration. Now, assuming initiating DB procedure will not toll limitation under the governing law, the contractor has no time to complete the DB procedure. And it would be reasonable for the contractor to initiate arbitration to save these claims from getting time barred. Say you act for the owner and want to challenge the contractor's failure to complete the DB procedures. Now here's the question. Is it suitable to raise this objection under the early dismissal procedures? And what consideration would be at play in making this decision? So I'm going to address this in two parts or sub-queries. And while I haven't come prepared with definitive answers or solutions, my hope is that this exercise will be valuable in shining the light on some issues unique to Rule 29. The two sub-queries are first, page number 2, please. I'm sorry. Yes. The first query is do objections based on non-compliance with DB procedures go to admissibility of the relevant claims or to jurisdiction of the tribunal? Second query is that do the early dismissal procedure cover admissibility objection? Page 3, please. Okay. So turning to whether failure to follow DB procedure is a jurisdictional or admissibility issue. As a starting point, it's clear that DB procedures are generally mandatory. While this would not be a good time to visit the contractual language of the relevant FIDIC contract and jurisprudence on it, you may note two related court decisions confirming this understanding up on the screen. But it is getting complicated from here. It's not clear whether non-compliance with DB procedures result in jurisdiction or admissibility objection. I would tentatively suggest that the answer to this question depends on what kind of DB procedure is at issue. DB procedures are of various kinds. Some dispute board adjudicate dispute, DAB, and issue conclusion, for example, ICC dispute board rules 2015, that are binding on parties until they place their dispute within the contractually stipulated period before an arbitral tribunal for final determination. other issue recommendations, such as DRB, and there are other procedures that fall somewhere in between, with discretion provided to the dispute board to issue recommendation or conclusion. The Dispute Avoidance and Adjudication Board, DAAB, on the FIDIC 2017 Rainbow Suit editions are typical examples where the DAAB can provide both informal assistance to resolve dispute as well as formal binding decisions. So my initial thought is that non-compliance with the DAB procedure pronouncing contractually binding conclusion subject to initiation of arbitration by the dissatisfied party for final determination by an arbitral tribunal goes to jurisdiction, whereas non-compliance with DRB procedure that only result in contractually non-binding recommendations would probably raise admissibility issue. And the Swiss Supreme Court judgment of 2016 up on the screen support this idea. In that case, I understand the court, although seized of the matter in a jurisdictional challenge where the tribunal have found its jurisdiction despite non-compliance with mandatory pre-arbitral conciliation requirement, observed that the tribunal ought to have suspended the arbitration and allowed the parties to comply with the conciliation requirement. Page 4, please. So I will now come to my second query, that is, do the early dismissal procedures under Rule 29 cover admissibility objections? Both the 2016 SIAC rules and 2017 SIAC investment arbitration rule provide for nearly identical early dismissal procedure, with one difference. The SIAC investment arbitration rule specifically provides early dismissal on the additional ground that the subject claim or defense is manifestly inadmissible. This ground is in addition to the two common grounds shared between the 2016 SIAC rules and 2017 SIAC investment arbitration rules, being that the subject claim or defense is first, manifestly without legal merit, and second, manifestly outside the jurisdiction of the tribunal. I should also mention that like the 2017 SIAC investment arbitration rules, 2017 SCC arbitration rules provision for the use of summary proof procedure by the tribunal to decide one or more issue of fact or law where such issues may concern jurisdiction, admissibility, or the merit. And so when viewed in this context, absence of admissibility as a specified ground under the 2016 SIAC rules raises the question whether admissibility-based objections are covered under Rule 29. As to why admissibility-based objection might not be contemplated under Rule 29, various reasons come to mind, but I don't know the answer. But one of the possibilities is that the decisions on admissibility objection, unlike the jurisdiction decision, are not ordinarily subject to court review of the SIT and cannot be set aside. So this brings me to my last point. The owner in our hypothetical that I started my presentation with has virtually three options through which to raise the contractor's non-compliance with DB procedure. The first one is to address it as a jurisdictional objection and go under Rule 28 of the SIAC rules. But there could be reason why the owner would not do that, including having run out of time under the time limit imposed under Rule 28, within which to raise jurisdictional objection. The second option would be to seek early dismissal of contractor's claim under Rule 29 for being manifestly outside the jurisdiction of the tribunal. And the third, to formulate it as an admissibility challenge and raise it during the course of the arbitration. These options perhaps provide some insight to litigation strategy and tactics. So I think I'm going to close my presentation with thanking you for your attention.
Thank you, Johan. Those are some very important practical points, and particularly the prima facie point. So say from an institutional standpoint, if we're looking at whether SIAC is prima facie competent, what often happens in these tier dispute resolution clauses is you will have one side that's saying they did comply with it and the other side saying they didn't. And at that level of analysis, then it's not really for the institution to decide, and it's likely going to go to the tribunal. So I think it's important from a guidance standpoint is that maybe a user should be considering jurisdictional objection and considering whether the SIAC early dismissal jurisdiction also includes admissibility, which may be two sides of the same coin. So thank you for that. Very practical and helpful, and actually what we see a lot in our cases. I would like to move to Eugen. Eugen has experience in both investment arbitration and commercial arbitration, has seen early dismissal from both the counsel side and from the arbitrator side. Eugen, could we ask you on your view on the genesis of early dismissal and summary procedure and arbitration to start, and then hopefully time allowing, I'd like to hear perhaps some summaries of the cases that you've handled.
Great, thanks. Delighted to participate today. In preparing for this, initially I thought this was a relatively narrow topic, but as you can see from the type of telecast we have, there's always something new to learn, and there are so many issues. I was going to say I'm Mr. Hoover today, which means I pick up whatever anyone else has not picked up, and I was going to say I only had 2 points, but given there were so many points thrown out, if there's time, there are a few more. But I'd first still like to stick to my 2 points, and it picks up on what Kevin has just asked, which is what is the background to Rule 29, and almost all the speakers have already touched on it. And I'm going to deal with it not so much from simply a historical analysis point of view, but to suggest to the audience and to the SIAC that how we look at the genesis of Rule 29 is important, because it will also educate us as arbitrators and as counsel as to the limits to the type of jurisprudence that we put before the tribunal. So it also, how we understand the genesis of the rule has an impact on how we approach the test that is to be applied. And the first point I would make is to emphasize again and again that even to date, the SIAC has introduced an innovation upon an innovation in coming up with the early dismissal procedure. You have heard again and again from the time of the 2016 when this procedure was introduced, a lot of commentators wrote, for example, early dismissal, this is the main innovation of the 2016 rules. Secondly, this is groundbreaking, it's truly innovative, even where people refer to the rule as having taken some form of inspiration from the exit Rule 41, as Eddie and Hawking and others pointed out. The key difference and the one takeaway for all of you is it's not the same. There are two reasons. The first, the exit rule only deals with early dismissal, not their words, SIAC words. So early determination or an early dismissal of claims. That's the first point of difference. It doesn't deal with early dismissal of defenses. The second point of difference is exit arbitration rules. For those of you who are familiar, deals with disputes involving state parties. And the SIAC to date is still the only commercial arbitration institution that has introduced a procedure like this. Hawking has talked about how other institutions have also taken inspiration and come up with various forms of response to the SIAC's procedure. But the most recent institution to do this is HKIAC. And even theirs is not an early dismissal procedure. It's an early determination, which is more like what the SEC has done. And it's also more like what the ICC say and LCIA say they already have. So the first point, innovation upon innovation, it's still unique. And this uniqueness is important. And the second point about the uniqueness is this. What was innovative about the exit Rule 41 that was introduced in 2006 is the fact that it introduced this notion of manifestly without legal merit. And that phrase has stuck with us because that's been adopted into the SIAC rule. But manifestly without legal merit introduces a conception that is different, as Eddie has mentioned, from summary judgment. It's different from striking out. It's not the same as a judgment by admission. It's slightly different. It's also not entirely the same as what exit jurisprudence will deal with, because exit jurisprudence is not that relevant to SIAC Rule 29. It's only relevant to the limited extent that it perhaps elucidates what manifestly means. And you don't need to go through a lot of ICSID cases to explain what manifestly means, because the ICSID cases tell you that manifestly just means what it says in plain English. It means clearly, it means obviously, it means something that you can explain without too much difficulty. And so that level of baseline is the same. The second aspect, which is the same, is that you are analyzing essentially a legal question, whether the claim or the defense has legal merit. And that question now takes me to the point of the test. That is a question that it doesn't entail a detailed factual inquiry. You should not have to investigate facts. You should be assuming facts. So if the matter is brought before a tribunal, the tribunal will consider, in the case of an application for early dismissal of a claim, the tribunal will consider the elements of the claim that have to be proven, and will assume the facts asserted by the claimant at its highest. So in other words, everything that the claimant has asserted, assume those facts at their highest, and examine whether the basic elements of the claim or the cause of action have been established. If at their highest, you cannot establish the claim, then the applicant, in that case, the respondent, will admit that case out. Conversely, if it's an early dismissal application of the defense, you do the reverse. First of all, the claimant will first have to establish that there are undisputed facts or incontestable facts that show that the full elements of the claim have been met. And then look at what the defendant has asserted, assume the respondent's facts at their highest, so assume the respondent's assertions at their highest, and examine whether the elements of the claim or cause of action have been impacted at all, if any of those elements are missing. So it's essentially a very hypothetical exercise, and that makes it totally different from what happens in court in common law jurisdictions. It does mean it's very narrow, but I suggest that in practice, it's actually a very powerful tool. The other point I would say about practice, and again, this is to explain why I keep saying SIAC is innovative, is because I think in practice, it is the early dismissal of defenses that actually matters more. And it's interesting, I think we haven't shown you any statistics, but it's interesting when you look at the SIAC statistics, that the majority of cases are involve applicants trying to strike out claims. But in fact, I think this is very powerful when it comes to applying to strike out or dismiss defenses. And this brings the SIAC's Rule 29 a lot closer to the 19th century notion of summary judgment in the first place, which, as Eddie pointed out, summary judgment was introduced in the common law system as a way to ensure that lenders or financial institutions can ensure that bills of exchange or checks are honored. And when SIAC introduced this in 2016, this was on the back of a user survey. And in our part of the world, in Asia, it's very important for banks. Banks and financial institutions for years have complained about arbitration because it doesn't have a procedure for you to obtain effectively summary judgment for simple debts. And this is a problem in Asia because whereas they used to like English courts, New York courts, and maybe now Singapore and Hong Kong courts, court judgments, as you know, are not portable. So they are stuck with arbitration for all the large markets that they want to lend into. And by the introduction of the early dismissal procedure in 2016, the SIAC has introduced a mechanism that complements what it was another innovation, namely expedited procedure. So you don't just have expedited procedure, a 6 months procedure, you've also got the possibility of ED. And that makes a big difference, I think, to banks. And it's still early days, it's still only 4 years, so you've got 32 applications, but I think that there should be more to come. So that's kind of my point on the on innovation and on the test. If you wanted me to go into case studies, I think the interesting case studies I have to share with the audience really come from, unsurprisingly, given my remarks, come from the world of early dismissal of defenses. And let me give you one example, just so that we're not speaking in the abstract. these are cases in which you've got you've got simple debt claim. They come out of sale of goods, they come out of trade, and essentially the liability to pay isn't in dispute. And on occasion, the respondent hasn't even denied the quantum. So you've got liability and you've got quantum admitted. The only defense that's been given, so to speak, is the fact that the respondent doesn't have money to pay. So it says, I admit liability, I have signed a document that admits the quantum, I just don't have the money to pay. In that situation, you could construe the fact that they don't have money to pay as not being a legitimate or legal defense, and therefore that is something that can be struck out through early dismissal. And I think one of the cases I've had involved an instance like that, and the application was made, say, June 26th, and basically by July 26th, within 1 month, the award was rendered. Most of the cases, I think, there are quite a few case anecdotes I can give, but I don't want to hog the mic for too long. I did want to say something interesting, though, about this two-stage test. So there is a two-stage test. If you look at the rules, the first is the discretion whether to hear the application, and the second is to apply the manifestly without legal merit standard. But the interesting thing in practice is that you don't take this analysis in 2 stages. An applicant essentially makes one application, and the application says, I want early dismissal. Here are the details of why that is so. The other side will respond and probably say no, and then the applicant will get a right of reply, and sometimes the non-applicant will also get a further right of reply. And there are a few observations here. First of all, there isn't necessarily a need for an oral hearing. In some of the cases I've done as arbitrator and as counsel, the cases were so obvious, they were all just done on paper. Second, there isn't necessarily a point in time where the tribunal comes back and says, oh, I want to hear you only on the first stage, or I want to hear you on the second stage. Because how it works in reality is, if the tribunal is minded to accept to hear the application and give you an early dismissal, in all likelihood, the tribunal will be rushing within that 60 days to give it to you, because the 3 or 4 rounds of exchanges will have expired approximately 1 month of the 60 days. And then another interesting point for the audience is, if you're applying to dismiss a defense, you will get a hint of whether you're successful by the fact that the tribunal at some point sends you an email saying, I hereby close the proceedings. The only reason the tribunal will have to close the proceedings is because it's going to render an award. And if the only reason it's going to render an award is because it's going to dismiss a defense. So that's something that's quite interesting that's come up. So that's what you should be looking out for.
That is a fascinating point, and perhaps a hint that I didn't want to have said. But of course, the position under Singapore law is that the closure of proceedings is just a case management technique and won't go to the set aside of the award, hopefully. But that is an important point. And additionally to that, the time for scrutiny. And that's why it's very important for the institution to help the tribunal, if it is an award allowing the application for early dismissal, to be able to review that award quickly. I would put it to all the panelists, and particularly Eugen's discussion on the early dismissal of a defense. Any remaining comments on when this should be used, comments on how civil law practitioners can use this, particularly during the time of COVID-19? Eddie, it's been a while since we've heard from you. Any remaining thoughts?
Not really, but you know, there's been a lot of talk about invocation of force majeure clauses here in this time. So conceivably, when a defendant raises a force majeure clause and say, well, I'm not supposed to perform this obligation, and that's been brought on by COVID-19, conceivably, this is something that could be put before the tribunal in an early dismissal application, okay, for the tribunal to rule on as to whether there's a valid defense or not. Yeah, that would be largely a legal issue that would go into the interpretation of that clause to see whether it is something that applies to the situation at hand. Yeah.
That is the kind of the classic case, and what we've seen a little bit. Yeah. Effectively, you have non-performance. the respondent is not denying that they didn't perform. Yeah, we didn't perform force majeure, COVID-19, and now it's a discussion of contours of the force majeure clause. So that's a particularly useful situation. Any of the other panelists, and just maybe to set the stage on the early dismissal of a defense, and without revealing too much, Eugen, which you have participated in, I think what's important and what you did very well as arbitrator is that the claimant still has to prove its case. So just because I think sometimes people get the wrong idea if there's an early dismissal of a defense saying there's no good defense to this claim, I think you need to be careful on that the claimant still has to prove its case. Any reflections there or advice for civil law practitioners, Eugen, to the extent that you agree?
Yeah, I do agree. And I think, in civil law, one other anecdote, I suppose, since this is framed as being for a Korean audience, in the cases that I've come across, Korean parties and civil law parties have been involved in almost every single one of the cases I was involved in that had an early dismissal. So that's an interesting point, including as applicant. Sorry, what was your specific question again? I was thinking of answering something else, but what's your question again?
Well, complete freedom, we only have a few minutes left. I was looking at the idea of any instructions for our civil law practitioners or guidance, but also on the early dismissal of a defense. But any remaining thoughts certainly would be welcome.
I did want to address, kill two birds with one stone, which is address DS's very interesting topic about admissibility and jurisdiction. And then also answer a question that Eddie posed in his presentation, which was about that case of, is it Miles and Bowl? And it's to say this, I think DS, if I'm not mistaken, you said something like, oh, I wonder why there is this test of manifestly without legal merit in relation to admissibility for investment disputes, but not in relation to commercial disputes. Why is there a distinction? Why do you not allow dismissal of admissibility? And then Eddie had asked, in an early dismissal context, could there be any application of the Miles and Bowl type of scenario, which, to recap, is a scenario where even if you could make out summary judgment, there might be some reason why the court doesn't want to give that to you and exercises its discretion not to. If I take the Eddie question first, in the Rule 29 context, you can have a Miles and Bowl situation because what Rule 29 does is it gives you the two stages. So even if the manifestly without legal merit standard is met, the tribunal still has discretion to not hear the application. And then to DS's question, why is it that there's no early dismissal for admissibility in the commercial cases as distinct from the investment cases? I think it's because of the character of the investment cases being against the state and being and thereby involving a lot of public resources. In a commercial setting, if the dispute is really over whether something is admissible, there is a tendency to think that as time progresses, that factor or that status of the claims might change. It wasn't admissible before, but that admissibility issue is something that might be addressable over time. So that's a bit like an overlap with the Miles and Bowl situation, where you can say, well, even if this isn't a problem now, it could be addressed later. And then the second point I would make is, even if you try and characterize an admissibility issue as a jurisdiction issue, one of the things I suggest, and I hope this doesn't come back to bite me if I ever had to argue it, is if you have to argue admissibility as jurisdiction, you're probably going to get into trouble because you won't pass the manifest standard. Because it's not manifestly obvious that an admissibility issue is a jurisdiction issue. It's usually something that's quite arguable. And if that is the case, and you frame it like that, then you run the risk that you don't pass that standard. And I think that is why there are not a lot of cases that have crossed the bar where it was an invocation of early dismissal of a jurisdiction case. I think there's only like one that has succeeded.
Johan, any remaining comments further to Eugen's comments?
Yeah, relating to my presentation, my practical advice to Korean client is that the understanding and analysis of the kind of nature of the pre-arbitration process is much more very important in reality. So that's my actual bottom line of my presentation.
And I suppose that also goes to the drafting of arbitration clause. Do you want to have these pre-arbitral steps? The position in Singapore following from Lufthansa and a string of cases is you may be bound to that bargain. Se-Yoon, the view again from Korea, anything else that you can share with us?
I think now, given the amount of information that we have passed around about Rule 29, I think it's about time that parties more proactively, as well as counsel more proactively, to think about utilizing this clause, especially under the COVID situation where the evidentiary hearings will actually be shortened than before. So you want to have more focus in the hearings themselves about the arguments, the evidence. So I think if you use it as a tool to trim down your arguments and defenses, I think that may work better at the end of the day.
And which may well be particularly important where parties are moving to virtual hearings and sort of answering the question, do we just want to replicate in-person hearings by virtual means, or is there a way to streamline? Ha Keng, the last word to you.
So I was going to suggest that if you have a case and you think you might want to use early dismissal, please bear that in mind when you select the tribunal, whether you want someone from a civil background or common law background, because I did some research when the rules were first published. By looking at exit cases and looking at the judges that the parties appeared before and how successful they were, and not to my surprise, you had better chance before a common law based lawyer than a civil lawyer. But this might change, yeah.
Or to the extent that the shorthand could be one of these panelists who obviously has a very keen understanding of how early dismissal works. Our time is now up, but I really do want to thank all of you panelists, Se-Yoon, Eugene, Eddie, Johan, Ha Keng. This provision in particular, this is exactly how we advanced and developed it, is from conversations with proper specialists. We have taken forward the discussion yet again, and on behalf of SIAC, we'd like to thank all of you. Thank you to all of our attendees, and we certainly hope that all of you will join the next installment of the SIAC webinar series. Thank you and good evening.
Thank you.
Thank you. Thank you, everybody.
Thank you.